Good morning. I'm speaking this morning with Professor Chris Mirasola of the University of Houston Law Center. We're going to be talking about the protective power, an issue that came up in the Trump versus Illinois National Guard interim order last week. I've gotten a lot of questions from people about the protective power since that order came down. Chris has written the definitive article on it that will be put in the chat notes. So we're going to talk about that today. Chris, thanks for coming to talk to me.
Happy to be here. Thanks for having me on.
So let's just get started with tell us what the protective power is.
Fantastic. Right. So the protective power is the theory that the president has inherent constitutional authority to use the military to protect federal functions, persons, and property. Since roughly the early 1970s, it's been justified by pointing to the Take Care Clause of the Constitution. As we'll get into, I'm sure, later, that legal theory has changed over time.
Okay, so give me an example of what is you use the May Day example, the famous Rehnquist opinion, 1971. I think this is when Rehnquist was the head of OLC.
Yep.
Just to give an example, I think that's a kind of straightforward, if
Yeah.
not necessarily uncontroversial, example of the protective power. So what happened there?
Yes, right. So in 1971, which was kind of a round two of using the military in this way, there are a number of Vietnam War protesters that descend on DC, and one of their tactics is to prevent federal workers from getting to federal buildings. And what the administration at the time does is use the military to both protect those federal buildings, right? To stand at the door of the DOJ, for example, to make sure that folks don't illegally come onto the property, and also to assist these federal workers get to and from work. Usually that meant like helping them get to the subway, for example, the metro, I guess, in DC. This was a repeat of something done in 1967. You have Vietnam War protesters again at the Pentagon. They forcibly make their way into the Pentagon wildly, and the military is used to force them out.
Okay, is it right to think about this? And again, we're going to dive deeper on this later, but is it right to think about the protective power as kind of a defensive power?
Yeah, that's generally correct, right? So, it is not offensive in the way that we think of a federal law enforcement officer being able to proactively go out and enforce some kind of federal law. Here, the military is being used to protect either a federal worker, a federal property, or the continuation of some federal function.
Okay. So this raises the question, again, this is just preliminary, about what the relationship is between the protective power and the Posse Comitatus Act.
Yeah.
So just remind us what the Posse Comitatus Act is,
Yeah.
what its restrictions are, what it requires, and how the protective power fits in.
Fantastic. So the Posse Comitatus Act, right, is a 19th century statute. It basically brings to the end, it's part of the end of Reconstruction. It prohibits using the military as a posse comitatus, or in more modern kind of parlance, to use the military in a way that would be the a kind of execution of the laws, right, for some kind of law enforcement function. And the Posse Comitatus Act says that this criminal prohibition exists unless you find an express statutory or constitutional exception. Statutory exceptions are easy, relatively speaking. They include
Yeah, go ahead.
Yeah, they include things like the Insurrection Act, right, which we'll
Yeah.
get to later. Constitutional exceptions are harder because it's hard to find anything in the Constitution that's particularly express in authorizing the president to use the military for a law enforcement function. Historically, the Department of War looked to Article 4. More modernly, they don't list anything. So that's the prohibition that we're dealing with. The protective power, as the executive branch has historically understood it, authorizes activities that they say fall below what is prohibited by the Posse Comitatus Act. So historically, it's been used to do things like temporarily detain someone before they're handed on to a federal law enforcement officer, or to, cursorily search somebody, again, before they're handed off to a law enforcement
So wait,
officer.
so you're saying the DOJ claims that the protective power allows for temporary detention and temporary searches,
That's how it's been operationalized by
and
the
that's
Defense
in a
Department.
context I assume, where they're performing some defensive function.
That's correct.
Yeah.
That's right. Right.
Okay.
So, like, you have a protester coming into the foyer of the Pentagon. You can temporarily detain them before you give them over to a law enforcement officer.
Yeah. Okay. And just to make sure I understand this, so the idea is that the Posse Comitatus Act prohibits the use of the military to enforce the law in the
Right.
domestic sphere. But the claim by the executive branch is that the protective power is not an example of enforcing the law. And therefore, even though it's not expressly authorized, the president can use the regular military or the National Guard, if properly federalized, to perform these protective functions because they don't rise to the level of law enforcement, right?
That's right. Yeah,
Okay.
that's right. Yeah.
And we're going to come back because there's a, in my view, a large gray area between
Yes.
the protective function and the law enforcement function, and we just touched on some of them.
Yep.
Okay, the last thing as background is um, my sense of the protective function is that it's something that's been, and I learned this mainly from you and some work in the government, that it's mainly been an executive branch idea. I mean, almost exclusively an executive branch idea. As you document, it's been justified in different ways and used in different ways at different times. And the cases that they cite, the executive branch cites, are two 19th century Supreme Court cases that on their face have nothing to do with the protective power as it's used. Can you just briefly tell us about those?
Yeah, great. So the two cases, right, we have In re Nagel and In re Debs. And Nagel is honestly the one that's more
Yeah,
on
let's
point.
just talk about Nagel because Debs is really not on point.
Yeah, it's really out there. So Nagel has to do with this like amazing fact pattern where you have a Supreme Court justice on a train in California. You have some two folks who are really angry with him, and they try to kill him on the train. There's a U.S. Marshal on the train, and he prevents them from attacking the Supreme Court justice. Question before the court is what authority that marshal had to protect the justice. And the majority of the opinion talks about how the president, of course, must have the authority to defend the federal government, right? Um, um, Importantly, though, when you get to the end of the majority of opinion, they point out the fact that there was a statutory authority under which a marshal could execute the functions of a sheriff in whatever state or territory that marshal was in. And in California, sheriffs were authorized to protect state officials. And so there was an on point statutory authority that was like the actual authority used to protect this Supreme Court justice. And so, as like DOJ has recognized in a number of OLC opinions, Nagel is at best like powerful dicta, is like the literal quote that is in DOJ OLC memoranda, right? You don't see that caveat in the current litigation about these National Guard deployments, but I think it's pretty telling, right? Because the Supreme Court just like hasn't spoken specifically to this theory of inherent presidential power before.
Yeah. So that I want to underscore that this protective power, which is hugely consequential in terms of the president's power to use the military in the domestic sphere. He's got other roots, but it's very consequential. It's never really been examined by the Supreme Court. I mean, what they did in Nagel, as you said, is dicta, but also, that was 140 or 30 years
It's
ago.
not modern constitutional interpretation. Yeah.
Lots of water under the bridge, including lots of executive branch practice. But as it's come to be understood, it's evolved far beyond Nagel, correct?
That's absolutely correct. Right.
Okay.
Yeah.
Okay. So that's background. Let's turn to why the protective power is in the news. And it's in the news because the president has invoked it in a way in these National Guard federalization cases in California, Oregon, and Illinois. The one we're going to focus on is Illinois because that was the subject of the Supreme Court decision.
Great.
So the statute in issue is 10 U.S. Code 12406-3, which I'm reading now, authorizes the president to federalize members of the Guard if he is, quote, unable with the regular forces to execute the laws of the United States. So that's the statute that they're interpreting. We're going to get to the interpretation in a second. But that sounds like it authorizes the president, if the predicates are met, the inability to, with the regular forces, execute the laws, that it authorizes the president to federalize members of the Guard for law execution. It's at least it sounds like that. So why is the protective power even relevant in these cases?
You're quite fantastic, right? So 12406 is in a section of Title 10 that has to do with mobilization, right? And so mobilization is a particular question for the National Guard and reservists more generally, because the National Guard on any given like Tuesday, for example, a Guard member is a civilian, and they need some kind of statutory authority to be transformed into a federal military officer, right? And 12406 is one of the huge number of statutes that does that. It has never been interpreted as a positive authority to authorize an actual mission, an actual task, right? So when we think about National Guard deployments, we always think of them in like kind of two buckets. One, what statutory authority are you using to make that member of the National Guard into some kind of military person? And then second, what is the authority for the mission that they're actually doing? Right. So 12406 is important here because it's authorizing them to become a federal military member. And then the protective power is relevant because it's the basis for the actual mission that they're going to undertake.
Right. Okay, good. And so summarizing that, in all three of these contexts, in these three states, the government was calling up the National Guard, but purported to be using them in a protective function and not for law enforcement. Right.
Yep.
And suffice it to say that there's been a lot of dispute about whether they've been limited to the protective function and whether they've gone past that and been performing law enforcement functions. I think Judge Breyer in California before the Supreme Court ruled that they had crossed that line and they blurred from protective to law enforcement and therefore violated the Posse Comitatus statute. Okay, that's background. So this case, the Illinois District Court enjoined at least the federalization or the implementation.
They were not allowed to be actually deployed. So they remained federalized but were not deployed.
Right. And so, but anyway, the question before the court was whether to stay that order, and the court viewed the question as whether these statutory criteria were met, whether the president was unable with the regular forces to execute the laws of the United States. Tell us what the court in the interim order posture held. It's actually hard to explain, to try to be as simple or simplistic as you can.
Yeah, I'll try my best, and you can correct it once if I get too far afield. So I think that the most straightforward way to articulate what they said was under this statute, right, subsection 3, the president must first be unable with the regular forces, right, to execute the laws. And so our question was, who are the regular forces? In a amicus brief that ended up being really important, Marty Lederman made the point that the regular forces, at the time the statute was enacted, referred to the active duty military, the active federal military that's always on duty at the local U.S. Army fort near you. And since in this circumstance, the president did not first use, or at least did not first determine that he was unable to use those federal military personnel, the predicate hadn't been met, and the National Guard could not be mobilized under this statute.
So that means that these deployments under 12406 are going to be hard to do.
Correct.
Because you basically have to show that the president is both authorized to use the regular military to enforce the laws, and has been unable to use the regular military to enforce the laws.
Correct. That's right. Yeah.
So let me just ask you a question about that. In what circumstance would the president have the authority to use the regular military forces?
Yeah.
And be unable to execute the laws and therefore need the National Guard? I mean, I don't understand why that is ever a possibility as a matter of fact.
So I think it depends on what unable means. So unable could mean that it would severely impact his ability to defend the nation, for example, to use the active duty military for this law execution function. So you might say, hey, I could use the Insurrection Act to deploy the Marines to LA, as the president did in LA. But if I used more than 200, it would it would be a detriment to my ability to protect the United States against an attack from China. And so therefore, I'm determining that I am unable with the active duty forces to execute the laws, and so I need the National Guard instead.
But does it mean that you read the court as saying that he has to first try, that he has to first uh,
Great.
find an authorization and actually invoke the authorization to use the regular military to enforce law in the domestic sphere, and then make a determination that he's unable before federalizing the National Guard under this statute? Is that what you understand the court to say?
I think with a lot of the like with a lot of these, it's hard to tell exactly what the court thinks, and I think there's probably division within the majority.
I see. It was unclear, and you think they may have been unclear on purpose.
I think that's right. I think it probably kept a coalition together. I could imagine a world where at least some of them thought that if the president just decided in a memorandum that he was unable to, that might be sufficient.
Yep. But he would, but the whole point was he hadn't shown that there was an authorization to do so. So doesn't he have to at least make that? I
That
guess they
case
didn't.
first.
Yeah.
And so like this was, I think, the other point, and I think and this is where the Kavanaugh concurrence kind of, I think, comes in a little bit, right? The majority, sans Kavanaugh, said, yes, you have to articulate what that authority is to execute the laws here, right? And in this case, the president's been relying on the protective power, which it has said, in this litigation and historically, doesn't constitute execution of the laws. So that can't be the predicate, right? That's being relied on for that active duty mobilization. You need something else first.
Okay. Let's leave that. Let's leave the court where that's what the court did, whether it makes sense or not. And that's what it
Right.
held in an
Yeah.
interim order basis. And that's going to be the rule as a matter of vertical stare decisis in interim order postures going forward until the court rules in a final decision on that matter. So in my piece last week, I argued that the president had other cards to other bases for using the military in the domestic sphere in contexts like he's wanted to use them before. And I mentioned the protective power, not using the federalized National Guard, but using the regular armed forces, the regular military. That's one possibility. Another possibility is that the president say, okay, if you think I need to show an authorization to use the regular military, I can invoke the Insurrection Act. That's
Right.
another possibility. I want to discuss those two, but first, you have taught me this in your writings. There are a whole bunch of things spread out, mostly in Title 10, a whole bunch of other statutory authorities for the president to federalize and use the Guard, especially. And just tell us about 10 U.S. Code 12302, because to my mind, this is a shockingly broad authorization to federalize the Guard, and I don't know why they didn't rely on this in the first place. Go ahead.
Yeah, the part about these mobilizations that most surprised me was the use of 12406. That was not in my on my bingo card. Great. So 12302 is a really frequently used mobilization authority
Frequently used.
Frequently used.
Yes.
Yes,
Okay.
correct. Very frequently used mobilization authority. It's used all of the time. And it says that when the president declares a national emergency under the National Emergencies Act, that the Secretary of Defense can involuntarily mobilize a member of the reserve, which includes members of the National Guard, to duty to respond to that national emergency. Period. And
Yes. That's it.
That's really literally it, right? I mean,
And when you say when he declares a national emergency, the statute doesn't tell what kind of national emergency. All it requires is the president to declare a national emergency.
That's right.
Under the the 1970s Act, Emergencies Act.
Right.
And so why wouldn't it have been, and the statute is pretty plainly worded,
Yeah.
pretty open-ended.
Right.
Why wouldn't it have been obviously easier? And I don't want to spend too much time on this, but why wouldn't it have been obviously easier for the government, instead
Yeah.
of using 12406,
Yeah.
use this provision, which doesn't require a showing of inability?
Right.
It just says the president declares an emergency and he can call up members of the Guard and
Right.
then give the protective function on top of that as what they're going to do after federalized. Wouldn't that have been a cleaner and legally safer and sounder, at least in terms of the statutory scheme, way to go?
Yes, 100% yes. I imagine that the reason they would use 12406 was largely bureaucratic. It takes some time to gin up the bureaucratic machinery to declare a national emergency, right? You got to get DOJ involved. You got to get OLC, presumably maybe to review the. to
I mean,
review.
you're thinking old. That's pre 2025 thinking about how the bureaucracy works.
Potentially, that's true. I think you still need some other action, right? Other than just the here is the directive to use the National Guard, right? Um,
But to
uh,
be fair, that's not a lot of, I mean,
no, it's not that onerous.
it's not
Yeah.
onerous, and it's mostly the president making a determination.
Yeah, that's right. Yeah, yeah,
Okay.
yeah.
All right. I don't want to spend more time on 12302, but it's out there and
Yeah.
it might be used. Let's talk about how the president, so I maintain, and this is not unique to me, that the president could invoke the protective power and instead of worrying about federalizing the guard under 12406, just send out the regular armed forces into the domestic sphere in a protective power capacity, i.e., this
Mhm.
defensive capacity. And I believe that executives have done that in the past. Yes.
Mhm. That's correct.
Yep.
Yep. Yeah.
So that is a possibility. Yes.
Yeah, absolutely correct.
Okay.
Yep.
And that would, but it's dangerous. I mean, it's politically fraught.
Hmm.
It If the president does that, then the court is going to have to examine
Yeah.
in a thorough way whether this protective power thing that the executive has been doing for 150 years is legitimate.
Right.
And it's going to have to define what the line is between the protective function that he would call up the armed forces for
Yeah.
and the law enforcement function that he can't
Right.
uh, that he can't do with the regular military under the
Right.
Posse Comitatus Act. Correct? So
Yeah.
is what I just said correct? And do you have any comments about that?
Yeah, no, it's absolutely correct, right? I mean, so I think the unavoidable issue now, right, is what is the scope of the protective power and what is like the actual legal theory for it, right? Because as I mentioned before, the legal theory has changed over time. And for the vast majority of its history, it was not rooted in any particular provision of the Constitution. If you read Judge Advocate General memos, which is like the chief legal officer in the Department of War, Department of the Army, they're littered with references to ideas of sovereignty and military necessity. There's no express, provision of the Constitution to be found in any of those memoranda.
Yeah. And
Uh,
even when they invoke the take care clause, as they are wont to do,
right.
I mean, it's not at all clear that the take care clause is an express presidential duty on the face of Article 2, but the protective power is not expressly on the face of Article 2
Correct.
under the take care clause.
That's right.
So it's not clear, but they don't have to. Um, but there are two questions. They
Yeah.
don't have to show that it's expressly in Article 2 just to use it. That's only if they have to show it's expressly in Article 2 to use it as a law enforcement function. But if they want
Correct.
to
That's right.
call
Yeah.
out the regular military and a protective function, then the question would be, does this thing really exist? Can the
That's right.
president really call in the regular armed forces into
Right.
the domestic sphere, even in a self-defensive capacity, um, without congressional authorization? Because that's what we're talking about.
That's right. And in the face of a tremendous body of statutory law that tells the president both like how to protect federal functions and when to use the military to assist in the protection of those federal functions, right? There is a statute that specifically requires that the Secretary of Homeland Security protect federal persons and buildings. For example, right, that's Section 1315 of Title 40. That's what the Federal Protective Service does every single day. If we're doing a modern Youngstown kind of analysis, right, there is an entire body of statute here that the executive branch has just like never addressed in
Yeah.
its internal thinking.
Yep. So let me just summarize what I take from that. There are these executive branch precedents, lots of them, and
Hmm.
executive branch practice about using the regular military in the domestic sphere for the protective function. Never been blessed by the court. And it would have to explain why the president, who has all of these statutory authorities to use the guard, which is the method that Article 1 contemplates for protecting violence and enforcing the laws in the domestic sphere and the like, and preventing insurrection. The contemplation of the Constitution is that you use the guard, what we
Right.
call today the guard. And so the court would have to address whether this entire scheme that the executives created is legitimate. And there's a decent chance that they might not bless it, I
I
think.
think that's right. Yeah. Yeah.
Okay. So do you, I mean, I don't want you to reveal anything you're not allowed to reveal, but do you have I mean, what is your sense? When I say that just because you used to work in the Defense Department. I
Right.
mean, do you have a sense about how a normal government, a normal pre-Trump
Yeah.
executive branch would be wary about doing this, I take it.
Yes, they would. And I think they A few things. So one is they would be using it for, I think, a more narrow range of functions. So the protect
By the
the
way, by it we're talking about the protective function.
That's right. Yeah, yeah, yeah. The protective power. So there are these instances of the National Guard accompanying ICE agents on deportation raids in the LA area, not even LA itself, right? Um, I would be very surprised if any other administration would use the protective power to authorize that kind of mission because it runs right into these thorny issues that we were just mentioning, right? About like the scope of the piece of the Posse Comitatus Act, and the scope of this theory of inherent presidential authority, right? We're far from any federal property in those circumstances. And so I think we would have seen a much more restrained use of the protective power, and likely not one in the middle of an American city without like really, yeah,
Yeah,
much worse facts.
and why use it when you have all these National Guard authorities, including the one 12302 that you just mentioned? Why not use this first? Who knows?
Yeah,
But it's legally fraught, it's
yeah,
politically fraught, so it's not at all obvious that they're going to do that. Who knows? They could.
right.
Okay, another option for bringing the military in the domestic sphere is to use the Insurrection Act, this cluster
Correct.
of statutes that goes back to the 18th century
Yeah,
that authorizes the president in very broad terms to it's actually several provisions to
yeah,
use the National Guard or the military for various law enforcement and related functions. And these are broadly worded statutes, and the president could invoke those and then either use the Guard or the military for. I don't want us to get into the weeds on the Insurrection Act, but for a whole variety, because, and I'm not suggesting it's easy to do, but it's very broadly worded authorization.
yep.
So assess that. I mean, what do you think? I don't want you to test the likelihood of that. I'll talk about the difficulties and the challenges in doing that.
Yeah, so I think it's interesting because I think it's kind of the flip of the protective power conundrum for the administration. Because whereas with the protective power, they have the benefit of practice, but the challenge of legal theory. Here we have the benefit of statute that's very broad, but the detriment, at least for them, of precedent, actual practice, right? Because there are relatively few circumstances when the Insurrection Act or any of its provisions have been invoked. And if you look at those invocations, they are in traditionally circumstances where federal and state non-military authorities are unable to actually either guarantee that a group of folks have rights that they are entitled to, or to guarantee that the federal government can execute its functions. It's not something that's being invoked every day, and you have a ton of internal executive branch memoranda across a huge breadth of time that articulates that fact consistently.
Yeah.
And so I think the challenge is the inverse of what we see with the protective power.
So let me say a few things about that. I agree the executive branch has, at least in the 20th century, the 19th century, some of the labor things, I'm not so sure,
Yep.
but at least in the 20th century, at least in the last 80 years, 90 years,
Yep.
has been very hesitant to use the Insurrection Act. And they have, as you say, these internal criteria where it's basically a severe last resort.
Yeah.
And the practice is not as robust, fair to say, as it's not terribly robust. There are a couple of dozen instances, depending on how you count,
Yep.
but not a whole lot, and
Yeah.
usually in fairly extreme circumstances. But is the court going to use these internal memoranda about executive branch self-restraint under the law as a basis for denying the president the power if he wants to use these broad statutory authorizations more aggressively? That seems like a stretch, or at least a tough one.
Yeah, I think it's very tough, right? And I'm not optimistic, right, that litigation is going to be the means by which an Insurrection Act invocation is defeated, right? I see the political risk
Yeah.
as probably a much more substantial deterrent. Frankly, I'm often kind of surprised that we haven't seen an Insurrection Act invocation yet. And in fairness, we have a lot of years left for this administration, and so it's not off the table. But yeah, I see that as a more significant guardrail.
Yeah. Okay, there's a whole bunch of other stuff to discuss, but we've gone on a bit. I want to just close by in a couple of ways. One, I just want to emphasize something that I guess I knew, but when I actually see the Supreme Court dealing with this, it kind of comes to the fore. All of these things we're talking about, the protective power, 12406, the Insurrection Act, there are not a lot. In fact, there are very, 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 very few, if any, recent Supreme Court cases on this.
Yeah.
The jurisprudence relies on 19th century cases, both on the Insurrection Act side and the protective power side. That's the basis for this modern practice. And I guess I just want to underscore that we don't know what the court's going to say. I think the court, when it looks at this stuff in an actual contemporary context, it's going to be thinking about this stuff in a fresh way. And I don't think they're going to blow off Martin versus Mott and Luther versus Borden in terms of deference to the president, but those are old and in some respects, distinguishable cases. I guess I just want to emphasize and see if you agree that the court has a lot of open space and not much precedent on which to interpret these provisions and these practices. Fair?
Yeah, very fair. There are very few cases that are directly on point, and the ones that are kind of tangentially relevant are again tangentially relevant and usually and exist within a practical reality that's just fundamentally different, right? These were circumstances when it was really hard to communicate with the president, for example, in ways that just like aren't true anymore. And the body statutory law that exists now just did not exist at the time that these theories were originally created to respond to practical challenges that the government was facing in areas like the American West, right, which was largely lawless at the time, from its own perspective. So, in any event, right, the world was fundamentally different, and as you say, like I think that that matters for these cases.
Yep.
Yeah,
Okay, there's a whole bunch more to discuss, and I think we'll discuss them later because we've gone on a bit.
yeah.
Thanks so much, Chris.
Thank you.